I'm absolutely delighted to have our Supreme Court Commissioner here to speak with us about the Supreme Court. I've been really looking forward to this presentation that she's going to do for us. So for those of you that don't know Rita Coyle-DeMule, she is our Supreme Court Commissioner and has been in that role since 2012. Prior to that, she was an Assistant Attorney General and also a partner at Robbins, Kaplan, Miller, and Cerisi. In addition, Commissioner DeMule has been served as a law clerk to the Honorable Michael J. Davis of the United States District Court, Honorable Donald Lay of the 8th Circuit, and here in our Minnesota Supreme Court, she clerked for Justice Kelly and Justice Coyne. Please help me welcome Rita.
Good afternoon, and thanks for being here. I am delighted to be here today to talk about sort of the Supreme Court, less about substance and more about numbers, as you can see today. Always have to figure out the clicker first. So what we're going to talk about today is numbers. I kind of like the gold, shiny numbers. You're going to be seeing a lot of these. The impetus for this discussion today came from a request from the State Law Library this spring when they were asking if someone from the Commissioner's Office could come and talk to the State Law Library about the Commissioner's Office and what the Commissioner's Office does for the court. That often leads us into, I'm going to kind of look over here every once in a while on my notes, often leads us into this statute that's been on the books for a long time, previously codified in a different chapter. But this statute talks about using resigned judges of the Supreme Court as commissioners. It's been on the books in one form or another since 1913. And it doesn't have anything to do with anybody in our office, in the Commissioner's Office, because none of us, of course, are resigned judges. But as we started talking to the State Law Library about what we could talk about in terms of what the Commissioner's Office does, we started looking at how resigned judges were used by the Minnesota Supreme Court, or when they were used. The research often leads you to cases in which you will see, rather than a judge's name, currently our opinions will say, for example, Lillehog, J. You'll see opinions from years ago that say Holt, Commissioner, or Gallagher, C, or Magny, Commissioner. So we started looking at who were these commissioners if they weren't in the Supreme Court Commissioner's Office, and what did they do? That led us back into sort of a looking at the numbers again and how the court has moved through membership changes. It's gone from 3 members to 9 members and back down to 7. So we're going to talk a little bit about that today. Numbers for the Supreme Court, how the court's workload led to number increases or membership increases and constitutional amendments, and a little bit about some of the highlights of some of the variations in the membership numbers. So we have to start with the Territorial Court. 1849, the Organic Act was adopted on March 3rd, 1849, and had a pretty straightforward provision. Supreme Court has 1 Chief Justice, 2 Associate Justices. Interestingly, each Associate Justice was assigned to one of the 3 judicial districts then in Minnesota and served as the trial court, in essence, judge in that district. So cost savings for a new territory. The justices were nominated and appointed by the President with the advice and consent of the United States Senate, served 4-year terms. And in the Organic Act, with the establishment of the Supreme Court, all of the cases that were then pending in the territory of Wisconsin that eventually became the territory of Minnesota were automatically transferred to Minnesota. So they came into being as a court and came with a caseload right at the outset. The first, The first court, Chief Judge Goodrich, Justices Cooper and Meeker were all appointed in 1849 by President Zachary Taylor. They came from 3 different states. These, of course, were political appointments, so each of these new appointees came with the endorsement of then President Taylor from Tennessee, Pennsylvania, and Kentucky, which meant they traveled. They did not actually convene the first court until January 1st of 1850. And if you look in Minnesota reports, the first opinion isn't written until 1851. Also, the first session of the court was really just Chief Justice Goodrich and Justice Meeker sitting. Justice Cooper did not arrive in time for the first term of court, which was held in Stillwater. So I think that it probably accounts for part of the lapse between the opening of the term in 1850 and the first opinion in 1851. None of them lasted long, again, because these were political appointments. Chief Justice Goodrich did 1 opinion, Snow versus Denoyer, I believe, and then was removed from office based on allegations of improprieties, and that's about as specific as I've found. I've never found any more information on what specifically he did that warranted his removal within the year. Justices Cooper and Meeker were replaced right away in 1853 when the administration changed over and President Pierce was in office. As a reminder, the decisions that were coming to them were coming from the district courts where one of them had been sitting as the judge or the fact finder. So this was an interesting opinion by Justice Meeker in essentially a personal injury case, judgment for the plaintiff for $40. The court's opinion, the 3-member court, reversed that decision, set aside the verdict, and remanded for what is essentially a new trial, except Chief Justice Goodrich dissented, concluding there was no error in the charge of the court because he was the trial court judge. Yep, he got it right the first time. He was pretty sure about that. And you will find a few of those opinions in volumes 1 and 2 of Minnesota reports where the 3-member court is reviewing the decision of one of their other members who is sitting as the fact finder, and the fact finder disagrees with the ultimate outcome, even if it's not a dissent. I came across 1 or 2 opinions in which there was a concurrence that said, you know, I think I did the right thing at the time, but I'm okay with the court's opinion. The Chief Justices for the Territorial Court, Justice Fuller, was appointed in 1951 after Chief Justice Goodrich was removed, but Justice Fuller ran into a different political problem. He was appointed, the Senate never consented to his appointment, and ultimately passed a resolution saying, we do not want Fuller to be sitting there. So Chief Justice Fuller sat, wrote 4 opinions, I believe, but then was removed in favor of Chief Justice Hayner, who came, you know, on the bubble between like a month before the election and was removed a month after the election when a new president was elected. And then finally you get to Chief Justice Welch, who brought some stability to the court in terms of serving through the territorial period. First justice appointed who went to law school, he went to jail and until the territorial court was dissolved. So the summary for the territorial 3-member court, the first court, Justice Goodrich, Cooper, and Meeker wrote a total of 16 opinions. Overall, between 1849, really 1850 to 1858, there are 81 opinions reported in Minnesota reports with just 2 dissents, which is a pretty good percentage. The record keeping is a little ambiguous. The court actually numbered its opinions back then, so some research suggests that the territorial court may have heard and decided somewhere around 100 to 120 cases, because you can see numbering that goes up to 119. But what we have in Minnesota reports is 81 reported opinions. So then we get to the state Supreme Court defined by the Constitution of 1857, Article 6, Section 2, 1 Chief Justice and 2 Associate Justices, very specific numbering, and leaves with the legislature whether or not to decide by a 2/3 vote to increase the number of Associate Justices up to 4 if the legislature deems it necessary. So the first court, Chief Justice Emmett was last name and now I don't remember his first name. So Chief Justice Emmett and then Justices Atwater and Flandreau. These 3 served together for the first 6 years of the state Supreme Court. It was a 7-year term at the outset, but Justices Atwater and Flandreau resigned in the 6th year of their term. Their opinions are found in volumes 2 through 9 of Minnesota Reports, 288 opinions in total. Let me just... Justice Flandreau was the only justice of the state Supreme Court to also serve on the territorial court. He served the last year or 2 of the territorial court and was elected out of the Constitutional Convention to the state Supreme Court. The first court, again, Justice Flandreau was still, for a period of time, you will still find in the state Supreme Court's decisions, you will still see them reviewing some of the territorial court's decisions where one of the members of the court was sitting as the fact finder. Here, Justice Flandreau was the opinion author for a decision that came up on appeal from the territorial, or one of the district courts during the territorial period, and reversed himself. So reviewing his decision on appeal, he then concluded that he made a decision below and the rest of the court went along with it. So decision reversed. 1865 through 1887, the court's workload is increasing, steadily increasing during this period of time. After the first 3 members of the court that were elected in 1858, there are a number of membership changes. I won't review all of those. Justice Berry was appointed in 1865, and he ends up serving the longest tenure on the 3-member court. He is there for 22 years. Which is long tenure for any member of the Supreme Court. But you can see, again, that the opinion workload for a 3-member court is increasing. Over the 15 years between 1865 and 1880, they have published about 1,050 opinions. And in the 22 years up to 1887, about 2,400 opinions. So 1881 is the first time the legislature can see the need for an increase in membership, and they pass the law that increases the number of associate justices to 4. So 1881 is when we start with the 5-member Supreme Court. And this is also when Justice William Mitchell comes on the court, one of the court's most notable members. He was on the bench or on the Supreme Court 19 years and wrote an astounding number of opinions. The number varied a little bit. I generally read around 1,500 opinions. I think if you do a Westlaw search, you come up with a little bit more than 1,515 opinions, in which he is listed as the author of the majority opinion, not just a concurrence or a dissent. It came up with about 50 dissents over that 19-year period. So he alone, as a member of a 5-member court, was writing about 80 opinions a year. Some of them obviously very short. You will see opinions that are about 2 paragraphs long that recite the facts, what the legal issue is, and the court just says, the lower court got it right, therefore it's firm. There's not really reasoning or analysis to it, but obviously it's a function of a lot of opinions that need to get out. If you have 80 opinions to write in your caseload in a given year. Justice Mitchell was actually not endorsed. Judges ran for, but they do run for election now, but in 1900, I believe it was the first election in which there were party endorsements for the members of the Supreme Court as well as the district court judges. Justice Mitchell was not endorsed by the party and ended up losing the election. I think also, I do not have the other person there. 1895, sort of a high water mark for the court. 1895 is the last reported decisions by the Minnesota Supreme Court that upheld a death penalty sentence. State versus Hayward, the court imposed a stay on the execution until the appeal could be heard, and then in the second opinion, upheld the imposition of the death penalty. There was another opinion in a civil case 20 or 30, maybe 20 years thereafter, in which the court considered some media coverage of executions, but this is the last criminal case in which the court upheld a death penalty. It was also the high point to that point in number of case filings for the 5-member court, when there were 695 cases filed that year. 1912 is the last year of the 5-member court, and again, some interesting numbers going on. Some of the records show the court was sitting in term and hearing about 3 appeals a day, 5 days a week when it was sitting in term. Obviously, I'm looking at Judge Rodenberg. I bet you have days where you hear more than that, so it doesn't sound that astounding. But this again was 5-member court, and they were sitting for extended periods of time before they took a break. Justice Holt was first appointed in 1911 and then elected for the first time in 1912. And remember, at this time, you stood for election if the election was held more than 30 days after your appointment. So they were appointed and standing for election in fairly short order. Justice Holt ended up having a 36-year tenure with the court in which he wrote over 1,800 opinions. We'll get a little bit further down the road here of the history and see Justice Holt also sat as a commissioner. So part of his 36 years includes 6 years as a commissioner after he resigned from the bench at the age of 87. So Justice Holt, maybe not fond of retirement. 1913, the legislature authorized the Supreme Court for the first time to appoint commissioners to serve as justices of the Supreme Court. And again, at this point, it's not resigned judges as it was in section 480.121, I believe, the statute that's on the books today. This statutory authority just allowed the court to appoint 2 people to serve as commissioners of the Supreme Court. They took an oath like the justices. They got the same salary as the justices. They could not practice law like the justices could not. And the language of the statute, I don't think I have it here, but they were intended to aid and assist the court. The legislature's intent for this seems pretty clear. It was meant to be a temporary measure. As soon as there was legislation or constitutional amendment that increased the membership of the court to 7, these commissioner positions would be automatically abolished. And this is where it gets a little vague, or I just wasn't able to dive into the records deep enough to figure out how these commissioners served. Commissioner Homer Dibble and Commissioner Myron Taylor were the first 2 appointed in 1913. Some of the historical records refer to these commissioners as shadow justices. And I'm not quite sure how shadowy they were. There is some indication that their votes might not have counted, that they were purely writing opinions. You know, they took what the court decided and put it into written words. But you know, you look at these opinions, they don't necessarily convey that this author shown at the top of the opinion did not vote in the case, because there's the usual language of the opinions. It'll talk about the court making a decision, or we looked at the record thoroughly and this is what we thought. What is clear is that they were doing a lot of work. Commissioner Dibble served for 5 years before being elevated to an associate justice position and wrote about, as authored, about 300 opinions, about 60 opinions a year. So it doesn't feel like that workload has decreased a lot from what Justice Mitchell was writing or Justice Holt. Commissioner Taylor was a commissioner for, lost my math, 17 years, and wrote about 900 opinions, quite a lot again. During this same period of time, you know, the constitutional process is ongoing. There were 3 constitutional amendments, 3 ballot questions proposed in 1914, 1916, and 1926. The ballot question was, should the Supreme Court's membership be increased to 1 Chief Justice and 6 Associate Justices? And they were rejected each time. The percentage by which these amendments failed decreased each time, but it was clear that the electorate wasn't quite ready for the Supreme Court to be up to a 7-member court. 1930, though, the ballot question is framed differently. The question was, should Article 6, Section 2 be amended to make provision for 2 elective associate justices to take the place of those commissioners that the Supreme Court has appointed? Remember, the legislature gave the Supreme Court the authority to appoint the commissioners, so now they're in the Supreme Court's hands, and I think what the legislature was conveying with this ballot question reframing is rather than having the Supreme Court in charge of how many extra commissioners might be appointed, should the Constitution be amended to change the membership of the Supreme Court? And this time, of course, the amendment passed. So by 1930, the membership is at 7. And the first person appointed is Justice Ingervall Olsen. My apologies to anybody from Norway. I see I misspelled his name here. He's an S-E-N, not S-O-N. Justice Olsen did serve as a commissioner from 1927 to 1930 and wrote about 180 opinions during his tenure as a commissioner. So he came to the court having already gotten familiar with the court's work processes and workload. Justice Charles Loring was not a commissioner before he came on. The last commissioner served just a few months before joining before the 1930 amendment. So after the constitutional amendment, the use of commissioners to supplement the court's work seemed to just fade away. There were no more appointed commissioners because Justice Olsen and Justice Loring stepped in to increase the court's membership. But by 1942, Justice Holt, again, age 87 in 1942, is ready to retire from full-time tenure as an active member of the court. He continued for 6 more years as a commissioner. And the interesting thing about this is you don't, again, I couldn't really find how they got to be commissioners once they retired. Justice Magny retired in 1952 and by 1953 was serving as a commissioner, and Justice Frank Gallagher retired in 1962 and by 1963 was serving as a commissioner. There's no appointment orders. There's no, like the court would do now when it has an acting justice, there's an order that says we need another justice for this case, and under the court's authority, under section 2.724, they'll appoint an acting justice for a case. These commissioners just really did serve, again, in that author capacity. And again, not clear if their votes counted or if they were purely authors of the active members' decisions. They continued to manage a fair amount of the caseload. Justice Holt, not surprisingly, numbers not that many in the 6 years between 87 and 93. Justice Magny, about 40 opinions as a commissioner between 1953 and 1953 and 1962. Justice Gallagher, quite a few opinions. I'll talk a little bit about this. These are just, again, these are the ones I showed you at the outset, these opinions that just talk about what the court's decision is without really clarifying if the commissioner is voting on the decision. And these are not decisions in which other members of the court were recused or took no part. Certainly right now with a 7-member court, there are occasions in which members of the court might recuse, and in order to constitute a court of 5, somebody else will be appointed, an active member of the Court of Appeals or an active district court judge. These are unclear whether the court is ruling as a court of 8 or a court of 7 or something less. I mean, there are occasions in which one of the commissioners authored an opinion and one of the active members of the court was recused, but the percentage of those opinions is very, very small, in the single digits at a minimum. I think, for Justice Gallagher acting as a commissioner, that's probably actually not a good example. Justice Magny acting as a commissioner, I think I only found 5 or 6 opinions in which there was somebody, an active member of the court, who took no part. And so if Justice Magny's opinion counted, then it was a 7-member court. If his opinion did not, it was a 6-member court. Was this, I don't want to say a problem, an issue? I don't think it was. The Supreme Court, as I mentioned, always had the authority since 1913. This is the 1923 version of the statute, to appoint someone, now it says retired judges, but a lawyer, a judge, a retired justice, to serve as a commissioner of the Supreme Court. By 1965, that authority is in section 480.21, and it is about appointing a retired member of the court to serve as a commissioner to do whatever the court needs the commissioner to do to assist in their duties. But as happened in other years, the workload continued to increase. By 1960, the court was often sitting in panels of 5. So 1960, this decision is 1968. I have to back up all the way there to see the numbering. So Justice Gallagher would have been serving in the commissioner capacity with this decision, and this is a 5-panel decision, which would suggest that Justice Gallagher's vote would have counted even though he was serving as a commissioner in this case. In 1956, a little out of order here, I apologize, the Constitution was amended to increase the membership of the Supreme Court to 9, not less than 6 nor more than 8 associate justices. But again, the decision on when to actually make those appointments essentially rested with the legislature, since the legislature had to establish the membership of the Supreme Court. After the constitutional amendment, filings continued to increase pretty steadily. Hearings in which the court actually held oral argument as opposed to special term decisions, writ cases, and non-oral decisions were increasing steadily year to year for the 7-member court, so that by 1972 there were about 270 hearings a year. And to give you an idea, currently the court has somewhere between 100 and 115 hearings a year, depending on special cases. Opinions were running at about 180 to 330 opinions a year. By 1971, the court had instituted a practice of using Justice Frank Gallagher as the commissioner retired justice, plus one rotating district court judge who was essentially appointed for about 3 months at a time in order to compose 3 rotating panels of the membership. So by the late 1960s and early 1970s, the court was essentially acting as a 9-member court by creating these panels of 3 using a retired justice and one rotating district court judge. I do not see Cindy Lair, but if she was here, she would tell you about talking to and working with district court judges during this time, that not the 60s. Cindy wasn't in law school yet. But judges from the district court and their experiences on being appointed to serve for a 3-month term. By February 1971, the Supreme Court had internally decided that it had to up the pressure on the legislature to gain support for an increase in membership from 7 to 9 active members. At the same time, that is when we see the first non-judicial commissioner for the Supreme Court, when Richard Leonard was appointed. It was intentionally a 2-step attack on the court's workload and managing the workload. The court worked very hard with the legislature to gain support for the membership increase, but also made a number of changes in its case processes by hiring Richard Leonard as the first Supreme Court commissioner, a non-judicial officer, assigning to the commissioner's office all of the pre-hearing screening of cases. And back then, this involved also sitting in the conference room with the attorneys and seeing if they could settle the appeal before they made a screening decision, sort of a rough forerunner of the Court of Appeals Family Court Mediation Program. Commissioner Leonard also was responsible for establishing the rotating 3-member panels and then assigning cases to the panels. And I am sure doing whatever he could to help the court move things along. But eventually in 1973, the legislature did amend section 480.01 to increase the membership to 8 associate justices. And I believe part of the court's decision to sort of lean on the legislature at this point to increase the membership to 9 was an agreement to not fill those positions once an intermediate appellate court was established. Again, if you go back into the Supreme Court's records and the Historical Society records, you will see work on behalf of an intermediate appellate court starting at least in the 1950s, if not the 1940s. And by this point, I think the support for an intermediate appellate court was fairly obvious. It was just a question of when it was going to get on the ballot. And so with the legislature's approval of a 9-member court, the Supreme Court knew this again, like the commissioner appointments from 1913, was intended to be a temporary measure. So the 9-member court, Justice Yetka, who was a big supporter of a 9-member court as well as an intermediate appellate court, was the first appointee, and Justice George Scott was the second appointee. And now a picture, not the best, of the 9-member court. I decided to go with 1980 so we could also see Justice Wall. This is taken, of course, in the old Capitol courtroom, which we'll look at a more current picture here in a little bit, and you can see how much it's improved. 1982 is the ballot question on the Intermediate Court of Appeals. And the proposed amendment to Article 6, Section 2 of the Minnesota Constitution was to establish a court of appeals that would provide for the relief for the Supreme Court. The measure was passed, of course, with overwhelming support. I think the vote was about 3-1 in favor of the Court of Appeals, and the first membership of the Court of Appeals is shown here with Chief Judge Popovich, Judge Foley, Judge Lansing, Judge Parker, Judge Sedgwick, and Judge Wozniak. Court of Appeals' first day of operation was November 1st, 1983. Sorry, I meant to include on here, part of the 1982 legislation involved an amendment to Section 480.01 and the court's membership. In 1973, that's the statute that gets amended. Let me just go back here. This gets amended to increase the membership to 8 associate justices. With the passage of the constitutional amendment to establish the Court of Appeals, the statute is amended again to reduce the membership back to 6. So the question becomes, there it is. No, sorry. The question became then, how is the court going to reduce the membership to a 7-member court? For a period of time in 1985, it was an 8-member court. After the Court of Appeals was established, there were 9 members of the court. The first member of the court to retire was Justice Todd in March 1985. This is a picture of the 1985 court after Justice Todd retired. And I believe I found about 180 opinions done by this 9-member court or 8-member court in that March of 1985 through the end of 1985 when the next retirement occurred. About 25 or 30 of those opinions, 1 member of the court was recused. So, you know, for some number, it was a 7-member court, but an 8-member court, about 150 plus or minus opinions. There were no dismissals because of an evenly divided court. There were opinions in which there were just some dissents, and I didn't gather all these, but just looking through the opinions, there were some big opinions that came out of the 8-member court. On January 1st, 1986, Justice Peterson retired, and the court automatically reduced down to 7. This is the 7-member court as of 1986. It's really hard to get a picture of these photos that have the glass on front of them, so with an iPhone at least. Here, of course, is the court today, the 7-member court. So the court has essentially been a 7-member court with without retired justices contributing to the work of the court since 1913. Appointed and retired justice commissioners, Justice Holt, the 2 appointees in 1913, Dibble and Taylor, Justice Olson, Justice Magny, and Justice Frank Gallagher, all together collectively served about 35 years on behalf of the court and are the authors of at least 1,200 opinions. Again, some of the research I came across talked about these retired justice commissioners as shadow justices because it's unclear from the records whether or not they voted on the disposition of the appeal. But even if they didn't vote, their contributions are fairly significant in the sense of the opinions that they wrote and contributing to the work of the court during a time when the court was figuring out how to manage increasing workloads. It does seem like 7 is the magic number, or if you're a Harry Potter fan, 7 is the most magical number of all. With that, happy to take any questions. Like I said, it was really more about numbers and less about substance, so we got a lot of time.
I noticed in the early territorial days, you mentioned how the opinions were really short. At what point did they start to actually cite to authority? Did you notice?
Yeah, yes. I don't know that I could pin it down to a specific year, but again, I think that's part of the time lapse. If you remember the first term being held in January, starting in January of 1850, the first opinions aren't published until 1851, or they have an 1851 date on them. They are citing to authority from other jurisdictions fairly early on, which I think would have complicated, if not delayed, the time it took for them to write those opinions, given research possibilities at the time. And Justice Meeker, I believe, had served as a judge in Pennsylvania, I think he was from. So they were familiar with the law at that point, or at least finding the law.
So it's just kind of whatever jurisdiction
was
around.
Right, yeah. Right. Certainly Wisconsin.
Yeah.
Yes.
Do you know when they changed the rule about retirement, setting the retirement age at 70, and what did the interval have anything to do with that?
That was part of the 1956 constitutional amendment. Maynard Persig, who served for 1 year on the Supreme Court, wrote a great article, advocating in the Minnesota Law Review, advocating in support of the 1956 constitutional amendments. And he has just one line near the end of that article that says, "Nobody thinks they're more competent to continue working than a judge who should retire." He was very much in favor of a defined age for Supreme Court justices to retire, or for any judges to retire. I didn't come across another justice that loved the work that much that they continued working till the age of 93. For the most part, I think Chief Justice Amdahl said at the time that they were advocating in support of the 9-member increase, as well as the constitutional amendment for the Court of Appeals. They were working so hard that their concern was that justices would be retiring well before retirement age, and so you weren't really getting the benefit out of them.
Did the justices always have law clerks to assist them?
I should know that, and I don't know precisely when they started using law clerks. Certainly by the mid-1900s, there are assigned law clerks to justices, but I don't know the specific start point for that.
We also have a question from the chat. The question is there any particular decision that made an impression on you?
Well, that first decision we looked at from 1851, it was just interesting given the way that the appellate courts work today in terms of deference to the fact finder and being respectful of the fact finder, to have them in the territorial days reviewing each other's decisions as fact finder and feeling free to say, I did it right the first time, or I did it wrong the first time. Good thing there's an appeal process. Yeah.
I understand that you clerked for Justice Coyne, who was in a couple of those photographs, and now you're back at the Supreme Court a little bit later. Could you comment on differences?
The primary difference in terms of what we're talking about today is probably in the work of the Commissioner's office. When Commissioner Leonard started in 1971, it was about getting your arms around this massive workload and helping the court move it along until they got the increase in membership and the intermediate appellate court. The next commissioner was Cindy Johnson, who was there when the Court of Appeals was established, and in that time between 1982 and November 1, 1983, she was, working to help get the Court of Appeals and its case processes established while also continuing to do that work for the Supreme Court. Now, I think I've been the beneficiary of, the people who perfected the work processes in the Commissioner's office. We know what the case flow is in the Commissioner's office from start to finish. I mean, we talk about how everything does come into the Commissioner's office at some point or another, but we know our objective is, as we say, if you know the layout of this building, to move it from our side of the hall to the other side of the hall. And it's a fairly well-organized continuing process for managing the workload in a continuous stream. Yeah.
We have another one from the chat. Are there any correlations between the number of justices and the number of cases heard and the population of the territory and the state?
Well, not that I can think of, either over the tenure of the court, 1850 to current. I can't think of any correlation. Currently, and as far as I know, as long back as I'm aware of, which may not be back to territorial, but cases are assigned to an author randomly. So there's no real correlation between the number of justices and case assignments or the population of the state. It's just how many cases do we have and how can we divide these evenly among the number of members we have participating in the case.
Please explain what you meant by shadow justice commissioner voting on a case. How is that vote documented?
Unclear. Yeah, that's why I'm not sure if shadow justice is an appropriate title for what the commissioners were doing right now. And for 40, 50 years or more, without going to the State Historical Society, I could look at documents now to figure out the vote on a case, the court's internal records. I don't know back when they were using retired justices as commissioners, where those voting records are, and whether they document whether or not a retired justice voted on the case. So at least some researchers have referred to those commissioners as shadow justices. I'm not sure they were too much in the shadows because, of course, their name is attached to a public opinion. They're writing the opinion on behalf of the court, and nothing in the opinion indicates that that author didn't participate in the decision.
Can you talk a little bit about the work that your office does now?
Sure. Like I said, everything comes into the commissioner's office at some point. My office is the starting point for petitions for review, the discretionary docket, which are requests for the court to take review of a decision of the Court of Appeals. There's somewhere, it depends, 650 to 750 of those filed a year. They stop in my office, they're assigned to an assistant commissioner, which makes that person looks at everything, the entire record, including at the district court, and makes a recommendation to the court on whether or not to take the case. The first stop in my office for mandatory jurisdiction cases, which would be appeals from the tax court, the workers' compensation, Court of Appeals, and first-degree murder. We look at all of those cases and make a recommendation to the court on whether or not those are going to be heard on an oral basis or considered on a non-oral basis. There is everything else. The original jurisdiction cases, which are very, very few writs and administrative matters, primarily attorney discipline. There are two assistant commissioners who are sort of responsible for managing those cases. Again, I like to think that we are the first stop for everything in an effort to decide how we move it to the other side of the hallway. But all of those cases end up coming back to the commissioner's office by the time a decision is made. We assist the court with the orders on petitions for review. We review opinions before they're filed for a final proofread and site check. And as always, we do whatever else the court wants us to do or asks us to do. Anything else? Thank you.
Thank you.